Good afternoon, ladies and gentlemen. Welcome to our lecture on Ryan Anderson's book, Truth Overruled. We're delighted to have you with us here today. My name is Jennifer Marshall, and I am the Vice President of the Institute for Family, Community, and Opportunity at the Heritage Foundation. When the Supreme Court imposed same-sex marriage across the country this summer on June 26th, many people concluded that the debate was simply over. Ryan Anderson was not among them, and he has written this book to explain why. Truth Overruled, The Future of Marriage and Religious Freedom, was released as an ebook just a few weeks after that court decision, and it was published in paperback yesterday. And we have copies here available for your purchase on your way out today. Ryan argues that the debate is not over, first of all, because proponents of same-sex marriage have failed to engage the case for marriage as the union of one man and one woman. For the last several years, Ryan has gone across the country lecturing at universities and law schools and other forums to debate marriage, becoming one of the leading national spokespersons on the issue. But the federal courts, including the Supreme Court, failed to address these arguments, much less effectively answer them. Rather, they simply set them aside. Second, Ryan points out the debate is not over because of the many new questions raised by same-sex marriage and the new voices and debates emerging in its wake, particularly the voices of the children of gays and lesbians and debates about religious freedom. In Truth Overruled, Ryan continues to make the case for marriage and frames the terms of these emerging debates. We're delighted to have you with us today to hear from Ryan more about why he has written this book and what he sees in the future for marriage and religious freedom. And we're also very glad to have an expert panel with us who have thought very deeply about these issues, to hear their thoughts on the book and on the future of marriage and religious liberty in the United States. I'm going to introduce each of our panelists, and then we'll hear from Ryan first and then from the panel. Molly Hemingway is a senior editor at The Federalist. She is a very accomplished journalist, and her work has appeared in a number of publications, to name just a few: The Wall Street Journal, The Guardian, The Washington Post, Christianity Today, and Radio and Records. Now, one of the reasons we are delighted to have Molly here today is that she's the kind of writer that Radio and Records would want to publish. I don't think any of the rest of us can claim to have had a byline in there. Molly does an extraordinary job at making accessible to the ordinary reader deep philosophical arguments about marriage and other fundamental issues in a way that few other writers have done. So we're very pleased to have Molly here today. Robert P. George is McCormick Professor of Jurisprudence and Director of the James Madison Program in American Ideals and Institutions at Princeton University. He also serves as Vice Chairman of the United States Commission on International Religious Freedom. Professor George is co-author with Sharif Girgis and Ryan Anderson of the book, What is Marriage? Man and Woman, a Defense. That book was published at the end of 2012, and we were honored to host Professor George and his co-authors here at the beginning of 2013 to outline their argument, which really has become the foundation of much of the work that Ryan has done over the last couple of years on the marriage issue. As just one example of the book's impact, Justice Samuel Alito cited it twice in his dissenting opinion in the 2013 Windsor decision involving the Defense of Marriage Act. We're delighted, Professor George, to have you back at the Heritage Foundation. Ilia Shapiro is a senior fellow in constitutional studies at the Cato Institute. He is editor-in-chief of the Cato Supreme Court Review, and he's filed more than 100 amicus briefs in the Supreme Court. He is also the co-author of the book, Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution. One of the reasons we are very glad to include Ilia on this panel is that while he is a supporter of same-sex marriage, he has weighed in on a number of occasions to defend the free exercise of religion and freedom of speech as emerging policies have collided with these first freedoms. Ilia, thanks for being with us today. Ryan Anderson focuses on marriage and religious liberty as the William E. Simon Senior Research Fellow in American Principles and Public Policy here at the Heritage Foundation. He also addresses issues of justice and moral principles in economic thought, healthcare, education, and he has expertise in bioethics and natural law, most recently applying those to the issue of assisted suicide. Ryan is also the founder and editor of Public Discourse, a daily online journal of the Witherspoon Institute out of Princeton, New Jersey. As mentioned, Ryan co-authored the 2012 book, What is Marriage?, with Professor George and Sharif Girgis. And the amicus brief he filed based on that book in the Obergefell case was cited by Justice Clarence Thomas in his dissenting opinion in June. So we are delighted that Ryan has written this book. We think it's very important for the future of our discussion on these issues, and we'd like to hear first from Ryan for a few minutes discussing that further, and then we'll hear from each of our panelists, and finally we'd like to engage you in a question and answer session. So over to you, Ryan.
Well, thank you, Jennifer, for that kind introduction, and thank you all for coming here this afternoon. I want to say just a few words of thanks also to Molly, Ilia, and Robbie for agreeing to be on this panel. In the past several years, Molly has demonstrated to me that people are still willing to be persuaded by the best arguments, as she was, and that people are still willing to stand for the truth even when unpopular, as she has. In the past several years, Ilia and I have publicly debated this marriage issue several times, including at Yale Law School. And he's demonstrated that people can disagree on this contentious issue while not being disagreeable. I'd say our debates were some of the most intellectually fruitful and enjoyable that I've participated in. And then for more than a decade now, Robbie has been a role model for me in how to conduct these debates myself. Robbie's one of the most popular professors at Princeton, not despite his controversial views on marriage and abortion, but precisely because of them. Liberal students love Robbie because even while disagreeing with him, they see the power of his arguments and thus they respect them. So in Truth Overruled, I try to embody the best of what I've learned from Molly, Ilia, and Robbie. It's one of the reasons why I'm so grateful that they would honor me with their participation today. So let me just say a few things about the book, turn it over to the panel, and then we'll entertain your questions. First is that I wrote this book more or less for everyone, whether they agree or disagree with me, and regardless of their political or religious backgrounds. This is primarily a work of philosophy, social science, and constitutional law. It has a chapter that's addressed to religious leaders, but even that chapter is addressed to helping them make a public, rational, reasoned case about the truth of marriage. We need to make that case in the public square because the truth hasn't changed, regardless of what 5 justices of the Supreme Court have said. And so we need to think through, how do we defend the truth, and how do we defend our rights to live in accordance with the truth in a new normal? The book follows lessons that I've tried to learn from the pro-life movement. And so I thought that we were in a very similar situation 42 years ago in January, right after the Supreme Court issued its Roe v. Wade decision. So let me just mention 3 lessons that I take from the pro-life movement and that I apply throughout this book. First is that pro-lifers rejected Roe v. Wade. They rejected it as an illegitimate Supreme Court decision. They said it was judicial activism that had no basis in the text, the history, the logic, or the structure of our Constitution. This was simply legislating from the bench. So what I try to do in the book is explain why that's very similar to what has just taken place on marriage. That Justice Kennedy and the 4 liberal justices simply got this wrong. Our Constitution doesn't require a redefinition of marriage, and it was inappropriate for these 5 justices to say so. The book explains why Chief Justice Roberts and the 3 conservative justices got the case right. And it goes through those 4 dissents that were filed, highlighting the very strong constitutional arguments that were made as to why this question should have been settled through the democratic processes. Second, what did the pro-life movement do after Roe? They protected their freedom to live in accordance with the truth. We sometimes forget that in the mid to late 70s and early 80s, activists on the left were saying that abortion is a constitutional right, and abortion is health care just like any other medical procedure, and therefore all citizens should be required to pay for abortion and all medical professionals should be required to perform abortion. The activists on the left lost that debate, and the pro-lifers won. The pro-lifers ensured through a variety of legal mechanisms their freedom to not have to pay for abortion or to perform abortion. And that freedom has been protected up until the HHS mandate. And now we see that new challenge being litigated through our courts today. We have to take the example of the pro-life movement, and the book tries to explain how we can protect the freedom of bakers and florists and photographers and adoption agencies and schools to live in accordance with their beliefs about marriage. Even if you're in favor of same-sex marriage, you should be able to say that the government shouldn't coerce or penalize those who are against it. And what I try to do in the book is to spell out the argument why. There's a lengthy chapter that responds to the analogy to racism. Why believing that we're created male and female, and that male and female are created for each other in marriage, is not at all similar to racism historically, philosophically, or theologically, and thus why the government shouldn't be treating it as akin to racism. Third and finally, the book looks to the witness that the pro-life movement has made for the past 42 years on that issue. Not only did they reject Roe, not only did they work to protect their freedoms, but they also worked to overturn Roe and to bear witness to the truth of the dignity of the unborn child. And we've seen this most powerfully with the Planned Parenthood videos of the past several weeks. This issue will not be won the next vote in Congress. It will not be won with the next general election. This will be an issue that will take generations to work on. Just like the pro-life movement 42 years later is still making progress. My generation, more pro-life than my parents' generation. More pro-life laws have been passed in the past decade than in the previous 30 years combined. So let me just mention in closing 4 things that the book tries to do to help us bear witness to this truth. First, it's how to make the philosophical argument for marriage and how to explain the likely consequences of a legal redefinition. I found that most people know in their gut what marriage is, but they don't know how to articulate it. Most people have a sense that redefining marriage won't be good for the institution. They don't know how to explain it. This book helps people, I hope, to make that case. Second, it's to understand the most recent social science on marriage and parenting and to explain those nuances to our neighbors. The media keeps touting social science studies that don't use large, random, and representative samples. They don't use the best methodology in social science because the media likes those studies because they come to the conclusion that the media likes. The best social science, however, comes to the conclusion that children do best when raised by their married mother and father. And so this book goes through that science and helps to elucidate where the controversies lie. Third, it introduces readers to some voices that have been silenced by the media. And these are the voices of children of gays and lesbians who love their 2 moms or love their 2 dads, but now as adults are speaking out on how they wish they would have had both a mom and a dad. These are the voices that the media doesn't want you to hear from. The media wants it to seem like Andrew Sullivan speaks on behalf of all gays and lesbians. So here I want household names to be made of Katie Faust and Heather Barwick and Bobby Lopez and Doug Mainwaring. And in particular, an insight that Heather Barwick had that same-sex marriage creates an institution for missing parents. Heather was raised by 2 moms. She was in support of same-sex marriage as a teenager and as a 20-something because she wanted her 2 moms to have the right to get married. It was only when she got married herself and she saw how her husband interacted with their children and that a father wasn't the same thing as a mother that she changed her mind about marriage and began speaking out. And then fourth and finally, it's to develop cultural institutions, civil society institutions that can help people live out the truth about marriage. In the same way that the pro-life movement created crisis pregnancy centers and a whole network of resources to help women choose life, we need to have an entire network of resources to help everyone live out the truth about marriage. Because the ultimate argument of this book is that gays and lesbians are not to blame for the breakdown of the marriage culture. Heterosexuals who bought into a bad liberal ideology are to blame for this. And it's only after 50 years of a cultural redefinition of marriage that Justice Kennedy and the 4 liberals could engage in a legal redefinition of marriage. And so the first place to start is going to be recapturing the truth about marriage and living it out in our own communities, and to focus on both law and culture, which is what the book tries to do. Thank you.
Thanks, Ryan. We'll turn now to our panel. And Robbie, would you like to kick things off?
Sure. Thank you very much, Jen. It's a pleasure to be here. I need to begin with a disclaimer, which Jen was kind enough to mention my role at the U.S. Commission on International Religious Freedom. Actually, I'm chairman now of the commission, and I need to say that I'm speaking here only for myself and not on behalf of the commission. Ryan, I'm very proud of you. I like to say, I wish I could say I taught the boy everything he knows. but actually I've learned a lot more from Ryan than I've taught him, including about the subject of today's panel, marriage and religious freedom. Ryan's work has helped us to understand that the redefinition of marriage is just that, a redefinition. It is not merely an expansion of an existing institution structured in a particular way, but now expanded to include more people who otherwise or previously had been excluded from the institution. Ryan has helped us to see that so-called same-sex marriage actually replaces a conjugal relationship with something new, and that is a conception of same sex, or for that matter opposite sex, a conception and understanding of, quote, marriage, unquote, as sexual romantic companionship or domestic partnership, replacing a traditional idea of marriage as a one-flesh union, naturally ordered to procreation, that would naturally be fulfilled in the case of any particular couple by having and rearing children together, if having and rearing children together was possible for them, the non-behavioral conditions of procreation obtaining. He's also helped us to see that under the redefined idea of marriage, marriage cannot serve the social purposes that it historically has served, joining a man to a woman as husband and wife, to be father and mother to any children born of their union, conferring upon those children the inestimable blessing of being brought up in the committed bond, the marital love of the two people whose coming together bodily brought them into being, and giving those children, of course, the additional advantage of being brought up with both maternal and paternal care and influences. The story that Ryan was telling toward the end of the woman who only came to understand the complementary and important contributions made by parents of the two sexes is a very familiar one, increasingly familiar one. Parents are not interchangeable, as Ryan has, male and female parents are not interchangeable or substitutable, as Ryan has helped us to see. Ryan's also helped us to understand that on the revisionist accounts of marriage, where marriage is simply now redefined as sexual romantic companionship or domestic partnership, its conjugal dimension now being eliminated, there is no principled basis for the norms that have traditionally structured marriage: exclusivity, monogamy, fidelity, permanence of commitment. Under the new understanding, there's no reason of principle why marriage has to be closed rather than open sexually, why it has to be a partnership of two persons as opposed to 3 or 4 or 5 or more in polyamorous ensembles. The concept of the throuple now, the 3-person couple, is becoming more familiar, as well it should be if you follow out the logic of the redefinition of marriage. The new understanding can't explain why marriage should be committed, at least in principle, marked by a pledge of permanence. Why shouldn't it be a renewable contract for a 3 or a 5-year term, or for as long as love lasts, or something like that? Why should it be a commitment to, at least a pledge to, stick together until death do us part? There's no conceivable explanation for that. And finally, of course, as Ryan has helped us to see, marriage thus redefined gives us no basis, no ground of principle for imagining that the state should be involved in the relationship any more than the state should be involved in ordinary friendships, or the state should be regulating bar mitzvahs or baptisms. It literally privatizes the concept of, quote, marriage, unquote. And the reason for that is that it's not marriage. It's not marriage any more than abortion is health care. If you think about it for a moment, the idea that abortion is health care is just preposterous. I mean, take the normal case where the pregnancy is not causing any risks to the mother's health. Why would you categorize abortion as health care? Nobody's sick. If a woman wants a baby and she conceives a baby, she's happy to be having a baby, we regard her as a healthy woman. If she suddenly changes her mind, let's say the boyfriend disappears or she gets mad at him or something, changes his mind, she now no longer wants the pregnancy, no longer wants the baby. Are we supposed to say she's sick? And then if she's sick then, and then she changes her mind again and wants the baby, she's no longer sick, Abortion's not health care in the same sense that marriage is not marriage. Ryan also, I think, calls attention to another important dimension of the problem, and this goes beyond the subject of marriage, and that's the court's intervention in the subject, its imposition of so-called same-sex marriage on the country in the first place. What this puts in peril is not simply the institution of marriage, but the very idea of Republican government in the same way that Roe versus Wade did, in the same way that decisions going all the way back to Dred Scott against Sanford did. The belief, the boast, the conceit that we are in fact a republic is put very much in jeopardy when courts, lacking any warrant in the text or logic or structure or historical understanding of the Constitution, simply come in and impose a particular point of view from among the points of view that reasonable people of goodwill disagree about and debate in a society. Lincoln was willing to go to the mat opposing judicial supremacy of the sort that he had in the Dred Scott case. He was willing to go to the mat because he realized that the very concept of Republican government was at stake there. It was at stake every bit as much as it was at stake in the secession fight itself. When Lincoln asks himself at Gettysburg, why was I willing to pay the price of the carnage of the Civil War? The answer is, that he himself gives, is so that government of the people, by the people, and for the people, in other words, Republican government, will not perish from the earth. Not just from the North American continent, but from the earth. And that's because he knew that the very idea of Republican government in the United States was an experiment. The aim of the American founders was to show that republicanism could succeed despite the fact that it had failed historically every time it had been tried, and Lincoln was very cognizant of that. So what's his critique of Dred Scott? Well, here we go back to the first inaugural address, and it's the same thing. It's that Dred Scott places in peril the idea of Republican government. Judges step in, they usurp the authority of the people, they override the judgment of the people, they turn what should be a republic into an oligarchy. And then finally, Ryan's helping us to see, especially when it comes to the religious freedom issue, the real dangers that we have in the country, dangers that conservatives have historically not been sufficiently cognizant of plutocracy. That is the power of elites, not simply intellectual elites, not simply political elites, not simply social elites, but also economic elites, to coalesce around a particular point of view, effectively rendering dissent from that point of view impossible or crushing it at every turn. And if you want to know how plutocracy relates to the current issue and to Ryan's book, just think about what happened in Indiana.
Thank you, Robbie. Molly?
I'm also glad that you brought up the similarities to the pro-life movement, Ryan. That's something I've been thinking about quite a bit in the recent months. I was reading in Clark Forsyth's excellent book on the history of Roe v. Wade, how when the day after it was handed down, the New York Times said something like, "Finally, we can put this abortion issue behind us." And of course, we look at that as really the launch of the debate about abortion. And I think there are so many similarities between the Obergefell ruling and Roe v. Wade, not just in that the elites definitely thought this would settle it for once and for all. I actually think the New York Times did the same exact thing leading up to Obergefell. Like, we can't wait for this to happen, to settle the issue for once and for all. And as has been evidenced by pretty much every day since that decision, the issue is so far from settled. It's shocking that a major media outlet would think otherwise. But like Roe v. Wade, Obergefell is a very poorly reasoned decision. You notice that even people who are big fans of redefining marriage to include same-sex unions or possibly other groupings will not defend the ruling as a good decision. They're just happy with the outcome. In that, Roe v. Wade actually did better. I mean, people didn't admit that for years afterward. But also just by removing the debate from the public square and also the elite consensus surrounding the opinion. I mean, it was very interesting to me as a media figure to see how unbridled the enthusiasm was from various media media types and just celebrating the ruling. And then what was also interesting was seeing how, despite that enthusiasm from the White House to CNN to BuzzFeed to whatnot, was that public opinion actually didn't change. I think it actually, the first poll right after that showed a slight uptick in support for retaining a conjugal understanding of marriage. So so people are very much ready to kind of think deeply about this topic in a way that they haven't been able to think deeply about it because of really bad media coverage on the topic. I myself first came to Ryan's arguments by trying to find out a little bit more about the debate. I had sort of an instinctive libertarian thought that, of course, marriage should include same-sex couples, and what business is it of the government's? And when I first started looking, what business is it of the government to limit marriage to one man, one woman? And as I started reading the arguments, I realized, like, wow, these are really complex, interesting arguments that have not seen the light of day in most media coverage. So that's when I started reading some of the arguments. And Truth Overruled is a great, apart from reading the Obergefell decision, which everybody should do, and the 4 dissents, it's actually fun to get into it. Truth Overruled is a great encapsulation of the arguments and also where we go from here. So we will be seeing so many debates. I mean, just yesterday we saw the situation in Kentucky with a government employee who might. There's tension between religious freedom and the new regime. There are so many private cases, not involving government employees, where individuals are coming up against a regime that is something that they're in deep disagreement with, and we are going to have. We're going to be seeing these battles at the individual level, at the congregational level, at the related to churches but not churches level, like colleges and whatnot. Some of this was brought up in the Obergefell dissents, but if you are interested in these topics and you just want a framework for discussion, whether or not you agree that marriage should be redefined or not, I would just say this is a very good framework for getting that conversation started and having it civilly. It's one of the things I appreciate too. Sometimes I think that there are way too few people who can actually have this discussion without getting too emotional. And it's very nice to be part of a debate where people can just have a patient, slow, thoughtful discussion and admit that people have different views. And many of us do want to see people have we do want a very expansive understanding of freedom for people to live their lives as they see fit. And I think a lot of us didn't realize that there would be so many conflicts with religious freedom. In fact, we were assured the opposite would be the case, that there would be absolutely no effect on each of us if we accepted this new understanding. And now that we realize that's not the case, whether you're looking at the very sort of scary thing that happened in Indiana, where big corporations kind of came in and took things away from people being able to decide something patiently, to individual cases. This is something we all need to think deeply about before we lose this very valuable civil discourse that we should seek.
Great. Thanks, Molly. Ilia, over to you.
Well, thanks very much for having me. I think this is my first public event at Heritage. I come here a lot for various meetings and forums and get-togethers of various kinds, but I guess it's only when they need someone who's a friendly critic in this particular case, and Ryan had a hard time finding someone who disagrees with him on marriage and yet doesn't think he's a bigot, and so I follow that little sliver in that Venn diagram, and I'm happy to play that role. Brian mentioned our debate at Yale Law School. The biggest thing that gave me pause throughout the course of kind of the marriage debate and the public discourse is when I had a majority of overwhelming support in the audience at Yale Law School. That definitely gave me pause. It's probably the only time that's going to happen there. And finally, it's an honor to be on a panel with Robbie George. Now, I knew him in college. I actually did not have a class with him, and perhaps that's why I'm on the other side now. The one time I took one of the classes he normally teaches, he was on sabbatical, so. Look, this whole debate shows the fundamental misunderstanding by both conservatives and progressives of state action versus private action. The reason why people are baffled, how can you be for same-sex marriage and yet also for the rights of the baker and the butcher and the candlestick maker and all these other people, right? And that's very simple. Who is acting? When the government acts, there are all sorts of restrictions that the Constitution puts in about not impeding on people's liberties and treating everyone equally. When individuals act, on the other hand, the burden at least should be, if properly conceived, on the government to prove why it wants to restrict individual liberty in some way, whether people are acting individually, in groups, for-profit, non-profit, whatever else. Unfortunately, Justice Kennedy further muddied those waters with his incomprehensible opinion. I wrote an op-ed saying Kennedy got everything wrong but the result, or he was right for the wrong reasons. As far as I can tell, I've reread the opinion so much it hurt my head. I don't understand what the rule of decision is here. Apparently you have a cup of due process, a scoop of equal protection, shake them together, sprinkle some equal dignity on top, wrap it in a poetic bow, and there you have it. Now this is, in fact, it's so poetic that there was a recent article, I think also in the New York Times, about people incorporating parts of his opinion in their marital vows, both same-sex and opposite sex. I mean, it's just, this is not the point of a judicial opinion, and that's why it doesn't read like one. And because he's messed up that, the dissents also didn't address the central issue, which is a simple case of equal protection with respect to licensing. Not with respect to who defines marriage or what is marriage, but licensing regimes. There's a lot of discussion now about occupational licensing and why, the attack on Uber and food trucks and Airbnb and the new information age economy. Well, similarly here, the question isn't what is marriage, the legal question. It's, does the state have a sufficient reason to draw its marriage licensing regime in such a way as to distinguish between same-sex and opposite-sex couples? I think it didn't. There were several years of litigation and all of the arguments that were put forth. It doesn't seem like, granting this license to same-sex couples hurts marriages of opposite-sex couples, hurts children. That's the sort of thing. I mean, the 14th Amendment actually is silent about marriage and marriage licenses. It's also silent about business licenses and occupational and education. I mean, the only thing it says that's relevant here is that if you give your licenses to one group of people, you have to give it to everyone else. Again, unless you have some very good reason not to. And so this is not about defining marriage. As kind of the nicest thing I think anyone's ever said about one of my amicus briefs was Ben Domenech, the publisher of the Federalist, who said, Kennedy just screwed up. He should have just cut and pasted Ilia's brief and said this. It didn't have to be mine. There are other cogent briefs, not all of them, but that provide an actual rule of decision. But at base, obviously, where I'm coming from is that there shouldn't be a role for government in marriage, for this public action in marriage in the first place. But if it gets involved, then it has to provide it equally. Curiously, I think Ryan's arguments are a lot more salient when he actually talks about kids. And so it's always been head-scratching to me why the debate in America has come about in this way rather than as it is in Europe, where same-sex marriage is relatively uncontroversial, while gay adoption is the point of dispute. Now, I think I'm in favor of gay adoption as well because we don't live in utopia. Kids need homes. I have colleagues and friends who are gay who have adopted that have wonderful families. I'm sure their kids are going to have much better outcomes than the norm, and et cetera, et cetera. But that's a whole separate issue. And I think all of Ryan's arguments, or most of them, in terms of the well-being of kids and so forth, really need to be redirected to the adoption debate rather than the marriage debate. Now, switching sides from public action to private action. That's why I defend the rights of individuals to be free from government coercion. This is not Jim Crow or institutionalized segregation, institutionalized monopoly power that requires discrimination against certain classes of people. The Albuquerque wedding photographer, if you don't get served by that person, there are 100 other photographers. There's no need to impose the restrictions by the state, the mandates, the compulsions. There's no need to foment clashes of values and stifle civil society in the way that happens the more and more that the state grows. Finally, I'll end with this. I think of all that's been said, other than the point about the actual Obergefell ruling, what I disagree with most about is the parallel between Obergefell and Roe. with same-sex marriage, there are no third parties involved. It's consenting adults. With abortion, at a certain point, and I don't want to argue about the whole legal or metaphysical debate about abortion, but at a certain point, whether you consider that to be conception, first trimester, second trimester, ensoulment, quickening, Peter Singer's 30 days, get your money back guarantee, there is another life in being that has rights. And so the real question is, where do those rights attach? Which isn't really a legal one. It's a policy, theological, not really scientific, science and but anyway. And the change in public opinion that Ryan has noted as well, I don't think will go along the same way. I think whatever demographic slice you look at, whether it be progressive urban dwellers, whether it be evangelical, rural men, whatever demographic you slice, the younger you get, the greater support there is for same-sex marriage. And I think that's going to, just as a matter of time and demographics, we're not going to have 100% of people agreeing, but certainly I think that's the progression that it's going to follow. It's not going to be where 50 years from now we're still at the same place in terms of public opinion, or even a little bit reversed as we were when the decision came down as with Roe. So in any event, good for the court. And while I echo Justice Kennedy's hope that both sides now respect each other's liberties and the rule of law, I stand ready to defend anybody's right to offend or to live their lives in ways in which I might not approve.
Thank you, Ilia and Molly and Robbie. I'm going to give, yes, please do thank our panelists. I'm going to ask Ryan to take a minute to respond, and then I'll probably take the chair prerogative and ask a first question, and then we'll go to the audience.
Great. Thank you to all three panelists. I agree with everything that Robbie and Molly have said, so I will just take 1 minute to say something in response to Ilia. And we don't have to spend much time on this because Ilia and I have hashed this out before, but everything Ilia said just now was responded to in the book. Ilia was a great foil as I was developing the arguments in the book.
And yet he doesn't list me. I didn't appear in the index when I did the Washington read.
I didn't create the index, so you can take that up with the publisher. But I'll just say two things. One, on the demographic front, is that that's what happened after Roe as well. All the younger people after Roe v. Wade were pro-choice. All of the elites were pro-choice. It looked like this would be a never-ending move in the direction of support for abortion, and then something changed. The pro-life movement started making arguments. They started bearing witness to the truth. They won hearts and minds, and the demographic shift actually started changing, so that my generation more pro-life than my parents' generation. There's no reason why that can't happen on this issue. It all depends on what we do. That's ultimately why I wrote this book, to equip people who want to start the marriage movement to respond to this bad Supreme Court ruling. Why do I think it's a bad Supreme Court ruling? Let me say something in response to Ilia's equal protection analysis. Ilia's analysis of harms and rights works really well from a certain libertarian viewpoint in which we're all autonomous, self-sufficient market actors. The problem with the libertarian worldview is that it can't account for children.
I actually believe in family communism.
Family communism is not something I believe in, or market communism or any other form of communism. The problem with the libertarian worldview is it can't account for institutions. And what's at stake here is whether or not redefining marriage will then in turn redefine parenting. And so when Ilia says I should focus my arguments at adoption and parenting, I address those issues. I also address the increased use of assisted reproductive technology that will be utilized by same-sex couples to create children of their own that will then be denied either a mother or a father. And I point out that these things follow logically once you redefine marriage. You redefine this institution that's meant to unite a man and a woman as husband and wife to then be mother and father. If you change that, you will change parenting. You will change how parents acquire children through technology or through adoption. And I think the libertarian worldview can't quite account for the interaction between institutions and rights and harms, and how an institution like marriage protects the rights of children to a relationship with their mother and father, and avoids the harms that come when marriages fail to form or fall apart prematurely. And so in that sense, there is no equal protection violation, because that union of man and woman, husband and wife, mother and father, is fundamentally different from a union of two men or two women. And so it's only if you can understand the institutional purpose of marriage can you then see why respecting the truth about marriage in law doesn't violate equality or the 14th Amendment.
Thank you. I'm actually going to go to the audience now, and I'll reserve my question if it doesn't come up in the midst of the debate here. So, front row right here. If you wouldn't mind identifying yourself through the microphone for the folks listening online.
Thanks. Nat Nasworth with the Christian Post. So Ryan, as you know, the Religious Freedom Restoration Act has a balancing test, and so not every religious belief is going to win. So if, sometimes you have a legitimate government interest to say, no, you don't have the right to do that. So when you think of that balancing test in terms of a private business owner like a wedding vendor versus a government employee, what's your thought process as far as, when that religious belief should be protected versus, no, we have a legitimate government interest to deny that, and also maybe in terms of the case we had yesterday that the Supreme Court turned down?
Yeah, great question. So I would say that in the private sphere, I actually think that we don't need a balancing test. We need a bright line rule. The same bright line rule that we've had on the abortion issue, which is that no pro-lifer should have to pay for abortion, no pro-lifer should have to perform abortion. There is no compelling state interest, least restrictive means analysis that would explain when you have to perform an abortion if you're a pro-life from a moral standpoint. And so I would say something similar is what we would want on the marriage issue when it comes to private action. And I imagine Ilia and I agree on that. And so at the federal level, there's the First Amendment Defense Act that Representative Labrador and Senator Lee have introduced. And it establishes that bright line that the federal government will never be allowed to penalize or coerce or punish in any way private actors because they believe marriage is the union of a man and a woman. When it comes to public actors, I do think the balancing test is necessary. And that's why I think the Kentucky clerk office was overreaching to a certain extent. Because here what was at stake in the Kentucky case was that it wasn't just an individual county clerk who was saying, I need to have an accommodation, I can't issue licenses for same-sex couples. She was ordering her entire office not to issue these licenses. And religious accommodation says you have a right under Title VII of the Civil Rights Act to a reasonable accommodation that doesn't introduce an undue burden on your employer. And your employer could be the government or a private agency. And the idea here is that citizens, because of this court ruling, are now entitled to a marriage license. So we have to balance those things. What North Carolina did, I think, is a better solution. What North Carolina did, they passed a law that said any county clerk or magistrate could notify their superior ahead of time that they have this objection, and then the superior would ensure that someone else in the office would provide licenses to same-sex couples. So this way, it's a win-win. The clerk with the religious objection has his or her conscience rights protected, but so too, no one will ever be turned away from the county clerk's office. I think those are the types of solutions we need to be seeking on the public side of this debate. And then I think a bright line rule saying government should never penalize or coerce a private actor.
Yes, in the back.
Thanks. Kathy Roos with the Family Research Council. A thought, Ryan, about one of your points in your opening remarks. I think you characterized the pro-life movement as being successful in keeping, protecting the right not to participate in abortion by not funding it and so forth. And I would just say that the pro-life movement wasn't that good. The reason why we don't have to pay for abortions is that the Supreme Court protect us. The pro-abortion movement went up to the court half a dozen times with the argument that the right to access abortion means for poor women the right to government-funded abortion, but the court said no every single time. It was the only place in which the court consistently said no to the abortion lobby. So we were protected by the court saying no. I mean, I know the ability for doctors not to. Okay, so here, it really will be. I mean, if there's a similarity, it would be the court that would have to step in to protect us from not participating. And so, in a sense, in abortion, you really could. The other side, who would tell us, well, if you don't like abortion, don't have one. To a certain extent, they were right. You didn't have to have one, and you didn't have to pay for one because of the court. But now, if you don't like same-sex marriage, you do have to participate if you're a vendor. You do have to perform, potentially, if you're a clerk. You do have to, affirm and potentially pay for in different ways. So this is a bigger thing in many ways than abortion. So I just throw that out there.
Sure. I mean, I don't think the premise of the question is quite right, because it wasn't the court that protected us. It was Congress and many state houses that protected us, and then the court didn't strike down those laws. So the actual protections came through Congress. It's the Hyde Amendment, it's the Church Amendment, it's the Weldon Amendment, it's the Mexico City policy. There are a whole host of federal policies that have prevented pro-lifers from having to directly pay for abortion, to directly perform abortion, or from taxpayer money in certain contexts from going to pay for abortions. And what you're pointing out is when those were challenged by pro-choice activists, the court upheld those policies. So I think the same thing needs to happen now. I mean, so I think both Congress and state houses need to pass good laws protecting our freedoms, and then we need lawyers and litigators that will litigate these laws and defend them so that the judges won't strike them down. So I think we're going to need both protections, and I think here Justice Kennedy hopefully would vote with us. If there's any kind of logic to his ruling, it tends to be he votes most often with the Cato Institute. If you want to predict his viewpoint, just look at where Ilia's filed his brief. And on this case, he would cut in favor, I hope, for freedom, for liberty. I don't know if any other panelists want to.
I would just like to add one more thing, too, which is I think that there does need to be credit given to the pro-life movement because they have spoken the truth for decades in the face of hostile courts and an extremely hostile media establishment who has kind of gamed the system in how they describe what's happening in abortion, how they describe the opposition to the same, and having that courage to speak the truth in the face of that hostility is a good guide. And you see that in the same way with this debate. People of goodwill have different ideas about marriage, how it should be defined, and whatnot. But the media has done such to me it's just a very harmful thing in making it where you can't even have these conversations and you can't express them. And so I think that when you're dealing with a very hostile media and hostile courts, it's nice to have someone that you can look to. And I think that the pro-life movement has done remarkable work for decades.
Kathy, I would just remind everyone that that decision, to quote Wellington, was a damn near run thing. It was 5-4. To decline to strike down the protections enacted by the people's representatives in the states and in the Congress under tremendous pressure because of the hard work of the pro-life movement. The late great liberal legal philosopher and constitutional theorist Ronald Dworkin, who has done even more than Ilia, I think, to promote the idea that courts have a very expansive role under the Constitution. They should step in frequently to resolve some of these big controversial moral questions, of course, always in the liberal direction. Dworkin, in his master work on the subject, which was called Law's Empire, says toward the end that in Law's empire, judges are the princes. And when we read that from a great liberal theorist, I think it's always advisable to remember the words of the Bible, place not thy trust in princes.
Look,
They are not our refuge.
It's not whether judges are active or passive, it's whether they're getting the law right. And so that's why whenever someone accuses a ruling or a judge of being activist, that just means they disagree with it. And it comes from both the left and the right. And so the issue here, under the 14th Amendment, if you raise a 14th Amendment claim, you're asking the federal court to adjudicate your federal constitutional right, yay or nay. Does the government have a reason to do this, to infringe this right that I'm asserting? That is properly before the court. You can say, well, that their theory of the 14th Amendment is wrong, but it's not about whether they're reaching out or striking down. And that's why I think conservatives have also gone wrong from the kind of the Borkian revival of the pushback to the Warren and Berger courts. Rather than saying, no, your theory of the Constitution is wrong, you're inventing things, they said, look, what right are you, unelected judge, to strike down or to differ with the people's elected representatives? That kind of thinking leads to John Roberts' vote in the Obamacare cases. Judicial restraint. Judges should judge. They shouldn't be either restrained or active.
I'm puzzled because it seems to me that people in the tradition of Bork from the beginning have been saying, your theory of constitutional interpretation is wrong. You're importing into constitutional interpretation something that is not discernible from the text, logic, structure, or original understanding of the Constitution. Rather, it's a particular political view. It might be progressivism. It might be libertarianism. But that is no more valid than inserting as your touchstone of interpretation Marxism or Catholicism or Islam or any other what John Rawls calls comprehensive view. And that, I mean, that's the fundamental conservative critique of both your position and Ilia and Dworkin's.
Which is why Roberts, in his dissent in Obergefell, went on this rant listing Lochner 16 times. And that's just, there are two things to the Borkian revival and revolution. One is originalism, and indeed, you're right, inserting things that are not in the text, not in the original public meaning. Well, originally with Borkia's original intent, that got revived to pronounce properly original public meaning. But second was judicial mode, and that's really where my beef is. It's not that judges should put a thumb on the scales one way or another. They shouldn't be restrained. They shouldn't be activist. They should judge, and then we can critique them whether they got their theory right or wrong. But it's not about we should defer to the elected branches. No, there's three branches of government and with checks and balances. And judges should, if they really think that their legal opinion, their interpretation of the law is X, they should rule that way regardless of what the political or other consequences might be.
Well, I mean, I think the truth of the matter is that the judge should defer to the elected representatives of the people unless the judge can show that there is a warrant in the logic or text or structure or original understanding of the Constitution to displace the people's judgment. And if the only way you can do that is by supposing that the founders intended or the founders somehow placed in the Constitution some comprehensive view, libertarianism, Marxism, Catholicism, or whatever it is, the judges should defer to the people. Otherwise, you're falling right into the trap that Jefferson warned us about after Marbury, which is creating the despotism of an oligarchy.
Well, this is a discussion for a different day.
I'm going to cut it off
That's
there.
how Burke subverts the Madisonian principle of a sea of liberty with islands of authority.
All right. I hope this conversation whets the appetite to pursue this more because it is an important debate. Did you want to say something, Molly? Okay. All right. Let's go back to the audience and grab another question right there.
Yeah, Bob Moffett, Senior Fellow at Heritage. Robbie, good to see you. I want to direct my question to you. You said something that I think is rather dramatic today, and that is you said that with the redefinition of marriage, the state no longer has a legitimate ground for interference in this relationship. That being the case, I mean, what, as a strategic matter, should we basically go for the full privatization of marriage, which was entirely a religious institution prior to this time, and forget the idea of trying to grant licenses, following the logic of that position?
I did not plant this question in order to be able to pause for commercial advertisement
That's
for
the
my
truth.
new article and online at the American Interest, which I suppose the polite way to put this would be to say argues for it. Really, it just points out that there simply is no logical basis now for stopping short of the entire libertarian utopia. The removing the law, going where Ilia wants to go. I mean, that's, I think, the real value, from a libertarian point of view, that's the real value of Kennedy's opinion. The idea that, well, there's not a rational ground for the distinction between licensing this guy as opposed to licensing that guy, I think is just a sideshow. I mean, the real value for the libertarians is now you've eliminated any ground for the state to be involved in the marriage issue at all. There is no principled basis for it. And if I were arguing a case before the Supreme Court, let's say, against legal recognition of polygamy or polyamorous relationships, I wouldn't know where to begin if I wasn't permitted to say, well, you guys should go back and rethink Obergefell. But I don't know if you feel the same way about this. I mean, do you see this as an opportunity, or do you think that distinctions can be drawn?
I've always argued that we're in a second-order world, and why the government, this is yet another area where government shouldn't be involved. And while, Ryan, I do believe in institutions, and that's why I often call myself a classical liberal rather than a libertarian, I don't think this needs to be a government institution. And so, just like for millennia, this institution did not have government involvement. It's fairly, the state licensing of marriage is fairly novel, if marriage itself is certainly not. And so is this an opportunity to fully privatize? I don't know. because I've always had the view that it should just all be done under contract and property law, and society and culture to prop up the institution and the importance of mother and father and good parenting and all the rest of it. But strategically, does this provide an entree into that? I don't know. I was rather disappointed in the years running up to Obergefell and even the years running up to Perry, the Prop 8 case, that no state, Oklahoma, Utah, Mississippi, whoever, passed a law saying if a court rules striking down our marriage law in this way, we're just getting out of the marriage business altogether. I think that's a lost Federalist opportunity.
So I have two thoughts in response to that question. One is that I don't think we should follow faulty logic to its logical conclusion. Or put it this way, logic that starts on faulty premises, I don't think we should follow to its natural conclusion. That would be like saying after Roe v. Wade, well, now we have no reason to protect against infanticide, so we might as well enshrine Peter Singer's philosophy into our laws as well. Right? So if you don't think the fetus is a person, well, the newborn child doesn't have any greater self-awareness or rationality than the unborn child, so we might as well allow organ harvesting from newborns. Right? That's logical, but it's a logic following from faulty starting points. And so I would say that what we should do now is preserve the goodness that remains, because the institution of marriage matters. It's a stabilizing force. It's probably the best anti-poverty social mobility institution known to mankind. And it's particularly important for the least well-off communities in America. And so I think privatizing marriage would only further increase the harms to a community like Anacostia. Because the people who are most influenced by the law's public teaching aren't the elites in Georgetown. They're going to be influenced by the books they've read, by what they're learning at university. The people most influenced by popular culture and by the government's teaching function of law are the people who have the least resources to other influences. And that's why it tends to be that the poor communities are most influenced by bad public policy. And so why would we want to further exacerbate bad policy? I want to challenge one other thing in your premise, and that Ilia also repeated. I don't think it's true that historically marriage has just been a religious institution. I think going back to the beginning, it's been both a natural and a supernatural institution. Actually, first it was a natural institution, and only later in human history did it become a supernatural institution. The ancient Greeks were celebrating marriages. They didn't know anything about the Bible, whether Old Testament or New Testament.
I didn't say it was purely religious. I just said non-governmental.
Non-governmental. I think the government, so let me rephrase it. Your church, your synagogue, your mosque can marry you. They can't divorce you. They can't do a paternity test. They can't enforce alimony payments or child support payments. And so the option here, especially from a limited government person like myself, is do we want to have a public institution up front that tries to channel male-female sexual desire in a stable, permanent, monogamous, exclusive relationship? Or do we want to just have one-off court decisions, the law's empire of these princes that Robbie mentions Dworkin favors, doing one-off decisions about who has parental obligations and duties, who's going to be paying for what procedures, on what nights of the week will the child be living with which parent. You privatize marriage, you open up a Pandora's box of endless litigation and government meddling into the family and civil society. So actually, state recognition of marriage is a way of limiting state power, which is another thing that I think has been completely lost in this discussion.
Just a point for Ilia and a point for Ryan. For Ilia, Socrates was married under the laws of Athens. Now, in many societies, of course, until fairly recently, Athens actually wasn't one of them. But in many societies, much of what we take to be law and government was done under the auspices of religious institutions because there wasn't a separation of church and state. So religious institutions were playing governmental functions, and the regulation and support for marriages was often part of the governmental function of the religion. Ryan, what you say is true, but given the commitments that you and I share to truth-telling, right? If someone, let's say a justice from a bench, if we were appearing before the Supreme Court of the United States, said, now, is there a logical ground, given what we've done in Obergefell, and we're sticking with that, Ryan, we're sticking. Is there a logical basis for us to deny Brittany, Dahl, and Kitten Bryn, the Massachusetts throuple raising their child, a marriage license? What would we have to say?
I think there we want to say they got Obergefell wrong. I mean, I just want to say we retain the goodness that we can, which includes highlighting for the justices that they should reconsider a bad decision that they've made in the past. In the same way that if Peter Singer goes before the court and says, actually, your Roe v. Wade decision suggests you should also decriminalize infanticide, what's been called after-birth abortion, I think we should just say that's a reason for reconsidering that Roe v. Wade is utterly lawless and should be overturned.
Molly, did you want to get in on this?
I just want to also add the point that marriage protects people at their most vulnerable, and that's particularly true for women and children. We can, it's such a complex institution, and I think we can talk about it in this abstract way, but women and men and their children are protected by this institution. It's very important that we think deeply about how we as a society view that institution for the benefit of all.
That's a nice comment on which to conclude, because we do at the Heritage Foundation view marriage as a fundamental institution of civil society and the underpinning for beginning to solve so many of these social problems that we face, whether in healthcare, or education, or welfare. So very, very important that we continue to debate the future of this most fundamental institution in our society. Well, would you please join me in thanking our panelists here today and Ryan Anderson for writing this book and talking about it here. And as I mentioned, the book is for sale in the hallway. We can point you, we had a better turnout than we expected for this quiet week in Washington. If we run out, we'll be able to point you to where to get it on Amazon. For those who are viewing online, it is available on Amazon. And this program will also be available online within 24 hours. Thank you for joining us.